Welcome, everybody. It's military night tonight. We appreciate you guys being here. Look forward to our visits coming up. Kim, would you please take roll?
Certainly. Senator Anderson.
Here.
Senator Furphy.
Here.
Senator McEwen.
Here.
Senator Pappas.
Here.
Chairman Landon.
Here. Thank you, Kim. The first bill for our consideration, House Bill 21, Wyoming National Guard Preference for Education. General, good to see you.
Good to see you, Chairman. How are you?
Please come forward and tell us about this House bill.
Hey, good evening, Mr. Chairman, members of the committee. My name is Major General Greg Porter, and I serve as the Adjutant General for the state of Wyoming.
Is your mic on?
I believe it is.
General,
I can hear
does
it.
it look green?
It is green.
Okay,
Okay.
good deal. Maybe,
Yeah.
yeah, I think
You want me to speak up a little bit?
Yes, please.
if you could scoot good and close to the microphone, General, that would help us.
All right. How's that? Is that
Very
better?
good.
Okay.
Awesome. Thank you very much.
All right. Sir, we're talking House Bill 21, right? The educational assistance. For those of you in the interim, all three bills that we're going to do tonight are as a result of the interim topics that we let me get caught up here. That we examined during the interim, sir. And what this one came down to was we had just a little background for those that may have not been in the interim. We had some soldiers, one soldier and one airman at least, come up and say, hey, listen, as we compete for educational programs such as nursing and dental programs, we're finding that we're not, even though we're members of the Wyoming National Guard, we're not treated on the same level as terms of a resident as residents are. So we can be screened out of serving, of obtaining this entrance into a particular program, even though we think by being members of the Wyoming National Guard, we serve the state in some way, shape, or form. As we studied in the interim, and you may recall, most of our schools actually do this in practice already. As a matter of practice, they try to keep the Wyoming National Guard members, they try to keep them on the same level of acceptance as anybody else. They still have to pay non-resident tuition. They still have to go through all that business, but by their state is no longer held against them as they compete with other members of the state in educational preference. So what this bill does is just codify that, what's really been a common practice into law, so that there really is no debate about it now on where that is. I believe, Chris, I don't know that I have the bill itself. I've got our backstory to it. And pardon me, Mr. Chairman, we'll get our stuff in a group here. Yeah. Thank you, ma'am. And sir, I leave it to your pleasure. It's pretty straightforward. Wasn't much discussion on the House Committee side, and there hasn't been a great amount of discussion in our interim as well. Certainly can go through it, but that's the sort of the background for that information, sir, and whatever your pleasure is on that one, sir.
General, I think we got a gist, and committee, how about any questions for the general on House Bill 21? Senator Anderson. Green, please. There you go. And
Is it green?
not yet.
It's red to me.
Yeah. Hit the button in the target line. There you go.
Yeah.
All right.
Mr. Chairman, I think we discussed the National Guard. Yeah, National Guard. And we discussed the reserves, and this isn't anything about the reserves. This is all about our Wyoming National Guard is all this is about, right? We're not.
General.
Mr. Chairman, Senator Anderson, it is strictly an attempt to retain and recruit members into the Wyoming National Guard is what this does.
Yeah. Okay.
Follow up on
Thank
that,
you.
Senator?
No.
You good? Senator Pappas.
Yeah, thank you, Mr. Chairman. Just, as a past commander in the Wyoming Air Guard and frankly, the past Assistant Adjutant General of the Guard, I know how valuable this can be. We had quite a few folks from surrounding states, and actually, I had one gentleman travel from overseas to do drill. Don't know if he'd go to school here, but the fact of the matter is, folks are working for our military department, are volunteering their time and their efforts to support our mission here. And so I think this least thing we can do is offer them the same tuition assistance that we do the people that live here. So on and for the bill.
So, General, I've got a question. It's been a while since I've been on the committee, but it seems to me that at one time, and maybe Chris can help too, I thought we talked about trying to get in-state tuition for our out-of-state Wyoming National Guard members. Where did that land? Am I remembering something that didn't exist?
Mr. Chairman, you're correct. I will tell you, this does not deal with tuition. This particular bill is only educational preference in that program. So this was not anything to do with the tuition side.
But General, and just a second, Senator. So I thought I heard you say that they still have to pay the out-of-state tuition.
Yes, sir. And misspoken on my part. So, yeah.
Okay,
So
that helps me.
Yes, sir.
Because go ahead, Senator Pat.
And Mr. Chairman, I just want to apologize too. I said tuition as well,
Yeah.
and it's an admission
Yep.
requirements.
General, I get that this is an admission bill. Having been 30 years at the college up in Casper, I thought I remembered that we were taking a little bit better care of our Guard members, and so thank you for clarifying that. But yes, this is an admission bill, and so committee, anything else for the General? Okay. Anything else by any of your folks, General, on House Bill 21? Do we have anyone? By the way, Representative Stiver, good to see you, and Mr. Chairman, good to see you. Would either of you, Mr. Chairman, do you have anything to add on House Bill 21?
No, Mr. Chairman, I think the committee understands the bill. It's their
Okay, thank you for being here, gentlemen. Appreciate it. Anyone else in the room want to testify on House Bill 21? Doesn't look like it. Kim, do we have anyone? Is Danielle helping us on the other side? Danielle, do we have anybody who would like to testify on House Bill 21?
Mr. Chairman, I do not see anyone in the waiting room.
Okay, thank you. I'm going to close public testimony on House Bill 21. What's your
Mr. Chairman, I
pleasure,
move the bill.
committee?
Second.
Moved by Senator Pappas, second by Senator Anderson. Discussion. Any amendments? Kim, would you please take roll on House Bill 21?
Roll call for House Bill 21, Senator Anderson,
Aye.
Senator Furphy, Senator McEwen,
Aye.
Senator Pappas,
Aye.
Chairman Landon.
Aye.
5 ayes.
Okay, thank you, Kim. House Bill 17 is the next bill for our consideration. Range management at military training areas. Representative, welcome to the front to join the good general, and gentlemen, tell us about range management at military training areas.
Mr. Chairman, members of the committee, Representative Stiver. There's an engrossed copy of House Bill 17, range management. Camp Guernsey is 61,000 acres. And back in July of 2021, the Secretary of Defense put a memo out that they can't use their funding to do the range management out there. And this is to help them get the range management program up and running. Let's see here. Where's that at? There's
I can surely talk it to, sir, and bring the folks up that weren't a part of the interim.
yeah, this was also an interim topic bill. They need the range management up there so they can keep wildfires down and move the cattle and the fences when needed for their training exercises. They bring in anywhere to the general fund. Biennium is about $376,000. They're requesting in gross copy of the bill, there's a $50,000 startup fee on out of the general fund. The what was that other than that? The AUMs for the current 7 leases they've got is anywhere from 28 or 2988 to 3222. The leases move the
Representative,
fence.
excuse me for interrupting, but can you give us those figures again on the ADMs?
The
28, you said?
AUMs is 2988 to 3222.
Thank you. Sorry to interrupt. Keep
Oh,
going.
I'm
Representative.
nervous, so I apologize. Like I said, there's 61,000 areas in Camp Guernsey and in Platte County. And we're trying to make sure that we do work with our neighbors with these leases and to keep the fire risk mitigation down.
So Representative, if you take us into the bill,
Okay.
I appreciate that overview. I think if you take us to the bill, it looks like then we're creating a department that used to be federal and we're going to turn it into a state department. And then we also have a fund that we're going to create. Is that right? with
Yes,
this?
sir.
Okay.
I'll take you through the bill now.
Okay.
Section 1 is we're creating the military department for range management operations. Council administration on page 2. This creates military department range management grazing. The military department shall administrate the range management grazing operations at Camp Guernsey and any other Wyoming National Guard training area. It's not the state lands, it's just the military department lands. They'll arrange for personnel and materials for range improvements, including maintenance, repair, and fencing, vegetation management, water development, wildlife rehabilitation and restoration of the management of invasive species. They'll determine the animal unit grazing usage. That's the AUMs. Maintain leases and neighborly relationships. On page 3, spells out their monetary. They can only have 200,000 in their account per biennium, and then it rolls back into the general fund. And they can't exceed that $2,000 at the end of the fiscal biennium. 200,000.
Senator Anderson.
Yes.
Yeah, thank you for that.
Thank you.
Go ahead, Representative. Keep going.
Page 4, the adjutant general shall submit a report by October 15th every year to the Transportation Highway Military Affairs Committee regarding the income and expenditures of what it's been spent on. And to support this, we're requesting $50,000 from the general fund to start the group up.
Okay. Thank you, Representative, for walking us through House Bill 17. Committee questions for the representative. Senator Pappas.
Mr. Chairman, I saw the action with the committee or the House action that the amount of the appropriation kind of varied quite a bit from, I think the high was 300,000. I believe it was changed to 150,000 and now it's down to 50,000. Can you give us some logic that was given to the House debate on that? And I would like to hear from the military department too about what they think their expenses will be.
Representative, it was kind of a tortured experience on the on the money side of things on your side. So can you walk us through what that was all about?
Yes, Chairman, Senator Pappas. When this went to the JA's, the Joint Appropriations Committee, they were requesting 300,000. With the individual on there, they thought it was way too much to be paying somebody to be a range manager, and they dropped it 150,000. And then gross copy, we worked with other departments where they'll be getting help from, and then we dropped it to 50. But it was a torture.
Senator Pappas probably would follow up with the question of what departments were mentioned as those that you're going to work with. Do you remember, Representative?
That was the Wyoming, I know his name. Yeah, the Wyoming Natural Resources and Wildlife Group.
Okay. Thank you for that. General, any thoughts you have on the debate on that bill on the House side?
Yes, Mr. Chairman, as I think we recalled it, initially, the initial bill had a couple of us approaching this a couple different ways. The first one was we were going to contract this out, and that's most preferable to us. The second one, though, had us hiring 3 AWIC employees. And that's where we initially came up with the 300,000, because we just didn't know how much. And once you start buying a vehicle, a trailer, some 4-wheelers, some office space, phones, all that kind of stuff. I think when we actually sat down with Mr. Budd and went through it, it came up to about 240,000. So that's where it started the 300,000 discussion. As joint appropriations kind of looked at it, though, they really were didn't think that it would take that much money, and so they took out the 3 AWIC employee sort of way to go. So the only place we have left now is for a contract. And so that went from 150,000 down to 50,000. I think we can survive that along this point. The only reason that 50,000 is there is all the lease money that comes from grazing goes directly to the general fund. So there's no stopping place for us to pay for somebody to contract it right now. So our last lease payments were in January. It's an empty pot right now. We won't receive new lease money until July or so. And sometimes our lessees, frankly, pay later when that goes. So we think right now with 50,000, we can enter a contract with whoever, bid it out, and then pay out of that 50,000 on a monthly basis until we get the lease payments in and we can start again. So that's kind of how the discussion went and why we dropped. The bill got changed. We went strictly to contract, and then we'll see how that goes. And a lot of discussion was, hey, if we need to come back to the legislature next year, because this is not, you're free to do that. But there was a lot of, I think, consternation on how much money that was. And I don't know that I ever did a great job of explaining that there is no pot right now for it to, there's no lease money for us to pay out of it. The whole purpose of this is to pay it out of lease money going forward. And so anything that's not used in the contract gets reverted to the general fund, Mr. Chairman.
Well, General, I appreciate that. The Vice Chairman and I were visiting with a couple of senators today about this bill, and there is some sentiment that we maybe could reach out even better and more effectively to conservation resource offices. Have you pondered any of that? I mean, are there other resources that are available to us that I just was curious as to whether that would work.
Yeah. Mr. Chairman, we've been grazing obviously on Guernsey for many years. And the whole issue is we've had federal resources doing it. Some of our environmental folks and that kind of stuff. So they can't do that anymore. So most what we have to get done is moving cattle around to get them out of the way when we train. And that's the largest thing that we have them do. There are some cultural mitigation, there's some range assessments, there's that sort of thing that goes on. But really the big bang for our buck here is making sure rounds and cattle don't meet or troops and cattle don't meet. And so that's why we're a little bit different than everybody else on that thing, sir. So maybe if I knew a little bit more about it, but I think everything's in place to do it. We just need a person to sort of manage that piece of it.
Thank you, General.
Yes, sir.
Thank you. Senator Pappas.
So thank you, Mr. Chairman. So that means that a range use plan is already in place and we don't need to redo a range use plans, nor do we need to do soils studies and geographical studies, you know, where the fences are and all that. All that's in place, correct? We're not needing to do that.
General?
Mr. Chairman, that's correct. We're going to continue on with the plans we have now.
Committee, any other questions? Senator Anderson?
Mr. Chairman, I'm having a hard time making this math come out. You got 61,000 acres and you lease it out and you have this income from it that says hundreds of thousands of dollars in lease fees. And I think I heard you say your AUM is about $39 or somewhere in there.
Mhm.
If I divide the 61,000 by 40 acres, which is usually what you figure for cattle, that's only 1,525 cattle and times $40 doesn't give me hundreds of thousands. What am I missing?
Gentlemen, can you help the senator on that front? Representative?
Chairman, Senator Anderson, the AUMs are 29.88 to 32.88. Hold on a second. There's 61,000 acres of grazing on Camp Guernsey, and they have 7 grazing leases right now.
Is that
Oh,
representative, is that 51,000 or 61?
61,000.
Mr. Chairman,
Senator Anderson?
so this is by acre, not by animal unit. Is that what you're saying? I thought it was by animal unit.
Mr. Chairman,
General?
it is by animal unit. Sir, and I'll have to, I'm not tracking the math that you've got there right now. So let me do some figuring and I'll see if I can help you out there. I think, you know, the largest thing is we will be able to manage this program and still be able to continue to put a generous chunk into the general fund, sir. I mean,
Wow.
General, I think, just remembering back, I think this is generated in this neighborhood for quite some time.
Yes, sir.
So I'm not sure how we're calculating, but
Mr. Chairman.
just from my appropriations days, I remember that line item, and I think the chairman back there can vouch for that, but representative, and then I'll go to Senator Pappas.
Yes, Mr. Chairman. The 2011 biennium, that was 350 or 365,000. 2013 was 383,000. 2015 biennium was 367,000. The 2017 biennium was 341,000. And the 2019 biennium was 376,000. It goes.
That's helpful. Thank you, Representative. Senator Pappas?
Yes, just want to clarify, I think you had mentioned that there were 7 leases. I understood there were 9 leases and there were 2 entities involved in those 9 leases. Just wanted to.
General, can you?
Mr. Chairman, that is
confirm
correct, sir.
for us?
There are 9 leases and 9 leases, 2 leases.
Yeah.
Yes, sir.
Okay, thank you.
I apologize. I missed that. 9 leases, but I thought I heard the good representative say 7. So
That's why I just wanted to clarify.
9 is correct, sir.
9 is correct. Okay, we're up to 9. Boy, that's getting you up close to, now we're starting, you see what I mean?
Maybe
Senator?
so, maybe so.
You can work this all out. Yeah. So,
That doesn't work for me.
yeah. Committee, Senator Furphy, Senator McEwen, any, Senator Furphy?
Thank you, Mr. Chairman. Let me ask about any liability issues that this grazing may cause. Have you looked at that? General, thank you.
Chris, go ahead.
Mr.
Thank-
Chairman, thank you. I am Chris Smith, the Senior Counsel for the Wyoming Military Department. Mr. Chairman, to Senator Furphy's question, it's standard. If we contract out, it'll be a state contract, obviously, and the standard rules about state contracting will apply. We will make the contractor have sufficient liability insurance for what they do. there's industry standards. I don't have those numbers in front of me, but our intent was the contract would require the contractor to carry general liability insurance similar to what grazers do when they're grazing on other people's land.
Follow up, Senator Murphy, Senator Anderson.
I have a follow-up. I wasn't worried about their liability. I was worried about yours when you shot a cannon off in their area. What liability do you have?
Mr. Chairman,
Mr.
Senator
Smith.
Anderson, believe it or not, we may have killed a cow or two over the years. What our leases are very different. You know, this is not where you have a section of land and you lease it to your neighbor and you walk away and you come back next year and say, give me the money. This is a very active operation where we have, you know, tens of thousands of troops in the summer wandering around. So there's a lot of integration that goes on, which is part of our problem and why we've had so many people involved in the process. But to that end, in our lease, it says that if we cause the damage to the property, cattle, we pay for it, current market value, as we may have done fairly recently.
I would say though, for the record, and I know this from my years, I even toured the facility a couple of times, and that's a very rare occurrence. But Senator Pappas.
I was just gonna say, I mean, you move the cattle because of maneuvers, right? The thing is in real life, they may run into cattle and animals. Maybe it'd be better if you just leave them there so they can get the boots on the ground training and then pay for a few cows.
General.
That's a way to go.
Yeah.
So we're trying to keep the grazing going on. We're actually one of only 2 military reservations in the U.S. that allow grazing anymore because it is somewhat of a hassle to do. But I think we owe it to our partners and our neighbors there that have been grazing on this for a long time. And it does really help us with fire mitigation and that. And that is my biggest fear is fire jumping off the reservation and damaging our neighbors. It's not a good day when that happens.
You bet. Senator McCune.
Mr. Chairman, General Porter, you ever thought about replacing the cattle with camels? Might be more realistic. Thank you.
Mr. Chairman, we leave that up to the leases on that, but note taken.
Thank you, General. Committee, go ahead, Senator Pappas.
Just one final concern. Since this does have an appropriation, it's going to be re-referred to appropriations again. And my hunch is they're going to try to strip even this 50,000 out of that. So I just wanted to just mention that. I don't know that I certainly don't want to remove this. There is the option to reverse what the House did and increase the appropriation.
Well, we'll certainly, when we take up the bill, Senator Pappas, we'll go through all of that. And, as soon as we get done with testimony, we'll work this bill. And that's a very good thought for us to remember as we get ready to work the bill. But anything else, committee questions for this distinguished panel here?
Mr. Chairman, if I could add, the Secretary of Defense made this ruling about in June of last year, saying cease and desist all non-reimbursable actions right now. So we've taken a little risk in the time because we've continued to allow that to happen, and we continue to allow grazing to go on. I will just say if probably 50,000 is probably as low as we can go in terms of being able to get a contract let. And if we're not able to, we will have to not graze on, if this fails, we'll have to cancel the leases and not graze at Guernsey is the net effect of this at the end. So I just wanted the committee to clearly understand what the impact would be if that were to occur.
General, I appreciate that. And just to go back to what the Vice Chairman has indicated, I think no question that if there's an appropriation, we have to send it to the Appropriations Committee, and would hope that maybe you and your folks could be there and we'll just talk it through with the Appropriations Committee at that time.
Yes, sir.
But appreciate it. Representative, anything more that you have? Okay.
No, Mr. Chairman.
Gentlemen, I want to go to public comment. I heard what's the word I'm looking for? I heard some vernacular over the weekend called roomies and zoomies. So we'll go to the roomies first and then we'll go to the zoomies. How about that?
No one's on Zoom.
How about that? And I don't think we have any zoomies tonight. And I'm not talking about Air Force personnel here. I'm Mr. Moline, welcome. You're a roomie tonight, so here we go.
Well, Mr. Chairman, you got me. That was a good one. I have been called a Zoomie more than once, but those that know me understand the reasons why. But Brett Moline with Wyoming Farm Bureau, sitting in support of this bill. One of the best ways to prevent fires, weeds, other not nice things that can not only affect this land, but the neighbors, is to prevent them. Doing good range management, keeping the grass down to a lower level is imperative for, if not stopping, at least slowing down fires. One of the fires that was over west of Laramie this summer, they said that they could tell where you had grazed because when the fire hit it, it slowed down so much they were able to get a fire line again around it. Areas that hadn't been grazed with tall decadent grass, we were a wee bit dry last summer, so that fire just kept going, but it essentially stopped where they had grazed. So having this good grazing management, not only for, to help prevent fires and weeds, but good management, good range management is a great way to not just maintain, but also to improve this range. You need to, as every one of my members knows that's involved in agriculture, you need to reinvest back into your resources. And I find that's what this is a reinvestment back into the resources to keep it productive. Senator Anderson had mentioned about 40 acres per cow. We have to remember that's for a grazing season. So either 9, 10, 12-month grazing season. So the acres for an AUM is much less than what that the annual acreage amount needed. So that's why, you're down, you got 40 acres per cow for a year, you're grazing 10 months, you're down to 4 acres per month. And that's where the AUM charge comes in. One thing I would, and I don't know how to say this, but I visited with one of my members up in Sheridan County that leases some military ground. I thought he indicated it was through the Wyoming Military Department. That area needs some serious attention too. And so hopefully, if this program gets started, they can not only look at the Camp Guernsey area, but also some of their other military ground holdings around the state. Is good range management makes for good neighbors. To stop some of these things and getting over onto the other private ground is imperative. Once it's there, we've learned that with some weeds called like leafy spurge. When it came in 1939, we thought it was a heck of a pretty flower. Now we're spending millions of dollars a year and we'll never get it eradicated. So prevention and then control is the way to go with these weeds. With that, Mr. Chairman, I've taken much longer than what I thought I would, but it took me a while to compose myself. So, Mr. Chairman, with that, I would sit for any questions.
Thanks, Brett. Any questions for the Farm Bureau?
Thank you,
Thank you,
Mr.
Brett.
Chairman, committee.
Chairman Burkhart, I apologize. I didn't mean to jump in front of you. I wanted to give you an opportunity for any thoughts you have on this bill. I apologize for not getting to you first.
Mr. Chairman, no apology necessary. So a couple things with the bill. I think you've heard that in the past, the money coming in has been over $300,000. And I know there's some questions on the appropriation. Actually, the appropriation at one point in the House went to zero and then came back feeling that we needed to fund an initial amount. So that 300,000+ has gone to the general fund after you take away operating expenses. So I think, the 50,000 gets it started, they'll pay for operating expenses and the rest then goes to general fund. And I think right now, all of us are in the position of every penny in that general fund is going to help us in the future. So that's one thing. The, grazing, I think is good. And Mr. Moline said it very well, good grazing, good neighbors. You know, and it's pretty fertile ground. It's been tilled with high explosives. So it grows well. So the cattle should be good. And I mean, you know, occasionally you might have to have a barbecue. But it's to manage that. The other thing is that the department is getting considerable advice from our own department of the Wyoming Wildlife Natural Resource Trust Fund. And I've seen what they've done with grazing issues, other places and that. And frankly, I would trust their judgment and they can provide advice. If you look in the bill sets up a process for them to administer this, but not directly do the lease management, the grazing management, but to see that it gets done, which I think is a very efficient way to do it. I think it relieves them of something the military department doesn't really do. They are not ranchers. It's our military department, and it gets help to them to do this in a way that makes money for them, makes money for the state, keeps the neighbors happy. I think it's a good program all the way around.
Questions for the chairman? Senator Pappas.
Mr. Chairman, thank you. Was there any testimony on your side of the building that talked about what would happen if we didn't pass this bill? And maybe General Porter could weigh in, but does this mean if we didn't pass this bill, does this mean that there would be grazing would cease on Camp Guernsey?
Mr. Chairman, there was some discussion on that, and it's my understanding the current leasees would be allowed to continue until their lease expired, and then the department would have to make a decision on how to best manage that. Potential for the leases to not be renewed, which means that you'd have the 61,000 acres overgrown with grasses and everything. You'd have a potential for fire. I think you remember a few years ago, we did have a major fire up there. And that's so it controls, that's one of the things to control with it. But I think there would be a considerable loss of income and a considerable loss of local goodwill. There was some testimony that the local ranchers who do lease it find it very valuable to them. So, and I think we want to do that. We want to maintain the goodwill and that, but that would be the result plus the loss of income into the general fund and to the military department.
Thank you, Chairman Burkhart. Mr. Smith, do you want to come up and confirm? It looked like maybe that those leases would have to end based on the edict from on high.
Mr. Chairman, that's right. As General Porter testified a little bit ago, he's taken some risk to allow grazing to continue under the federally funded employee supervision that we currently have while this bill percolated through the interim and now through the session. All of our leases allow us to terminate them on so much notice to give the grazers a chance to move the cows, but we would have to terminate the leases if we didn't have a way to run a program.
Thank you for confirming that. Senator Pappas.
Yeah, question for Mr. Smith. How long are these leases? I'm sure they're staggered end dates, but how long are they? 5 years? 1 year? What are they?
Mr. Smith.
Mr. Chairman, Senator Pappas, the current ones are 10-year leases. We used to do 7-year leases. We went to 10-year just because it's quite a burden to renegotiate leases. And so they are 10 years and they were all entered into at the same time. And this, I think, is year 6 or 5 of that 10-year period.
Senator Pappas.
Follow up. Okay, so that obviously the federal government knew we were in these leases. They will not allow us to finish out the lease using whatever federal funds and assets that they weren't parties to the leases.
Mr. Smith.
Mr. Chairman, Senator Pappas, the leases are with the Wyoming Military Department. I doubt there is anyone in the Department of Defense that knew we were leasing property. The guidance from the Secretary of Defense last summer was far broader than that. It wasn't a directive to us to say stop grazing at Camp Guernsey. It was that all actions that were supported by federal employees or federal agencies within the DoD that had a tangible benefit to a third party that was not reimbursed to the DoD had to stop. So I think they were dealing with bigger issues than grazing at Camp Guernsey because there were a number of programs out there that had slowly grown within the DoD in terms of support to certain agencies. And that's what they intended to stop in the budget constrained environment I think they were anticipating we're about to live in.
Further questions for the gentleman in front of us? I have one, and Chairman Burkhart, this might be for you. I guess it sounds like you're satisfied that this relationship that we have planned with the Wildlife and Natural Resource Group, Mr. Bud, is going to be workable, and he's the one that is going to be the boots on the ground to make sure we're getting good management up there. Is that how that's going to work? I guess I could use a little bit more on that.
Excuse me, Mr. Chairman, I am satisfied that will occur. He's already helped draft one of the larger amendments that the House put in place because, as you notice, it's an engrossed bill and looks quite a bit different than what the interim committee bill looked like. And he provided a lot of that input for that. So personally, I'm satisfied that that'll continue, make use of his expertise in that area, and plus it's free expertise as another state agency. I don't think he's back charging us, so to speak, for the help.
Mr. Chairman, I can't speak for the senators we spoke to today, but I would say that just commend you all on your work, because I think that's exactly where I think the idea was from the senator that he wanted to go, is let's see if we can get some help. And it sounds like we've done that. So committee, anything else before we go to public comment? General, anything, any final words on this one? Okay. We might have to come back to all of you. Let's go, anyone in the room who would like to make any further comment on House Bill 17? Does it look like we have anybody? There's nobody in the Zoom room, no Zoomies. So I'm going to close public comment on this bill. What is your pleasure, committee?
Move the bill.
Senator Anderson moved it. Senator Furphy, second. Discussion.
You want some changes?
We're going to go to that in just a second here,
okay.
Senator, but
All right.
we can do that right now. Let's take this one page by page just to make sure we're not missing anything. And anything on page 1, committee? Are we good on page 1? Let's go to page 2. And we're working from the engrossed bill, by the way. Your green copy. Anything on page 2? Okay, Senator Anderson, page 3. Okay. Anything on page 4?
Mr. Chairman, I'd like to amend page 4, line 11, line 10 and 11, and change that to appropriated $200,000 from the general fund to the military department. It seems like we say $200,000 2 other times in here. That's what they will revert back. So they have that amount, and then they get their leases in July, I think they said. And so then they'll have more money in there than the 200,000, and they could revert that back next session.
Do I have a second?
I'll second it just for discussion.
Okay, Senator Pappas, second.
Well, thank you.
Go ahead.
My issue is that when I heard testimony that the original was 300,000, and that was actually to have 3 FTEs we have state employees doing the work. So with putting 200,000 on, is your intent that we have 2 employees
No.
Then I think maybe $200,000 you may be pushing it. I don't think appropriations may even survive the 50,000, but my concern is that I think we have to have a justification for 200,000, not just because are we going to spend $200,000 on a contract? Maybe, but maybe not in this next year. I don't know. Maybe I could have the general come back and the difference between $50,000 and $200,000, where would you see that money going? And would it be more appropriate to be 100 or maybe 50 is too tight for you, but maybe $200,000 seems a little excessive for what we're going to be doing. I just want to know. I don't feel comfortable
General,
with
the
that number.
the sentiment from Senator Anderson is to get you the help you need.
Yes, sir.
And I think Senator Pappas is asking, can you do it for 50? So what are your thoughts?
Yes, sir. Mr. Chairman, I think we can. I mean, that was part of the problem that we went a little high because we simply don't know once we push the scope of work out, how it's going to be bid or if anyone will bid on it. But as we've been working the math in our heads since the 50,000 came down, we think that we can start to parcel it out because we'll be supplemented by the grazing leases, in the July timeframe. So if it's more than 50,000 for, 3 or 4 months, then we're going, I think that's a little unrealistic. We're probably going to have to take a step back and figure out what's, how to approach it in the future. So I appreciate Senator Anderson and would like to do that, but I also understand, they choked on it the first time that they saw that, 6 digits. I can certainly think that it could happen again, sir.
Senator Pappas.
And my issue is not so much, I think appropriations may try to strip it out and we can try to put it back in on the floor. The issue is that if we do something different, then it's going to have to go to a committee with a House. If we can keep $50,000, we can avoid the committee and it'll go into law. So I think we have to think about in those lines.
Okay. Senators, any other comments on the proposed motion on the floor? Senator McKeon.
Mr. Chairman, I just want to echo Senator Papps's thoughts on that. I think if it goes back to the Joint Appropriations Committee or we try to get through this, I don't think we'll ever get there with what we're doing right now. So if they can do it for 50, I think we should leave it where it's at. And I think we'll have a better chance of getting it through, sir. Thank you.
Thank you, Senator. Anything else on the motion? We have a motion on the floor to take lines 10 and 11 and move that from 50,000 to 200,000. All in favor of the motion, say aye.
Aye.
Aye. Those opposed, no.
No.
Okay, that 3 ayes or 3
Don't we have-
noes and 2 ayes, by golly. We're back on the bill. Senators, any other proposed amendments on House Bill 17? Okay, question having been called. Kim, would you? Thank you, Kim. Senator Pappas has a proposed amendment. By golly, thank you for catching us on that. Kim, you're the best. Okay, so Senator Pappas, would you like to? Well, except
I think it's,
I think,
Mr. Chairman.
I think you have it, senators, if you just find it in your packet. Go ahead, Senator Pappas.
Mr. Chairman, I think this actually came from our LSO folks. I think it's just some cleanup language. On page 1, line 6, after appropriation, insert providing for an appropriation. So it's just some additional language.
All in favor of the amendment, say aye.
Aye.
Any opposed, no. That amendment has passed. Okay.
Now I
thank
call
you.
for the question.
Yeah, there we go. Now I think we can have a question on the bill. Thank you, Kim.
Roll call vote for House Bill 17 engrossed. Senator Anderson.
Aye.
Senator Furphy. Senator McEwen.
Aye.
Senator Pappas.
Aye.
Chairman Landon.
Aye.
5 ayes do pass amended.
Squeak by.
Who, By the way, committee, who would like to handle range management on the floor? Sure seems to be that those guys that went through the interim, with this bill.
Whoever you
I
like.
think Senator Pappas would do a good job of that.
That would be fine. I'd be glad to.
If he
Well,
doesn't like 200,000.
Senator Pappas, he's got you and I right behind him there on the
Yeah,
floor.
yeah,
You know what I
you
mean?
betcha.
So, okay, well,
All right,
Senator
Senator
Pappas, there you go.
Okay.
All right. Okay, the next bill committee for our consideration tonight is House Bill 22, Wyoming Military Code. And General, welcome again. Thank you for being here. Help us with House Bill 22. And I see the representative and Mr. Smith. We've got the full extraordinary panel again on
Yes, sir. I
this
have a
one.
lot of help. Yes, sir.
So General, the floor is yours.
Thank you, sir. For members of the committee, this also was an interim topic that we studied. And the reason that this came about was the realization on our part in the military department that our military code was unusable for its purpose. It hadn't been, it closely follows Uniform Code of Military Justice. That's what this is modeled after. And it hadn't been updated in over 20 years, our Wyoming military code. And so as we started trying to utilize that and take a look at it, we found that it simply would not work in the environment we have today. Chris Smith has done a really great job of laying a chart out that kind of talks about the revisions. And it's a complicated bill because it is 19 pages and there's a lot to it. And sir, if it pleases you and the rest of the committee, I will turn it over to Chris and we can walk through the bill in detail to give the committee some awareness of what's going on there.
General, thanks. And I'll do that. And Representative, you and the chairman being here and standing by, that'll be helpful too. So Chris, take it away. Thanks for being here with this one.
Thank you, Mr. Chairman. So House Bill 22 before you, it's longer than it really has in terms of substantive, because as you all are well aware, if you change one word in a section of the current statute, you have to publish the entire section of the statute. So going through the bill, and I believe we may or may not have gotten you, I had a chart that we prepared, and then that's what I'll use to kind of go through the substantive parts of the bill. So throughout the bill, there are a number of changes because
Smith?
some of the sorry, sir.
I apologize. Real quickly, committee, this handout right here, I think is what we're going to be operating from. In your left hand there, Senator McKeon. Yep, there you go. McKeon. And Senator Furphy, do you have that? I think now we're set, Mr. Smith. So
All right,
thank you.
Mr.
Please
Chairman.
continue.
So throughout the bill, there are a number of changes that, for example, changing courts martial, which is plural, to court martial. It just was wrong throughout the code. We also had a number of titles such as marshal of a court martial, which is decades old language that has no meaning anymore. Additionally, there's a reference to the Judge Advocate General, which is a 3-star active duty general in the Air and the Army back in DC, and it really meant the state judge advocate for the Wyoming Military Department. So that was just wrong. And it was for those kind of reasons, and the ones I'll get into as we go through the bill, that created this bill. So the first thing I want to point the committee's attention to, so on page 1, it just talks about all the different sections that are being changed in the existing code. Starting on line 8 on page 2, at the very bottom is the change. And this was recommended from the Attorney General's office because the current language says the governor, upon the advice of the Adjutant General, shall promulgate rules and regulations. In the executive branch, the governor doesn't promulgate the rules. The agency head does. The governor then adopts them or signs them into effect. So that's all the reason that the governor is taken out there at the bottom of page 2. Moving on to page 3, this is 1912-101, and you can see beginning on page 5, the current statute references and this is my visual aid, it references the entire manual for courts martial, which is this entire thing, which is military rules of evidence, rules for how to conduct a court martial, the punitive articles, which are the crimes, as well as a variety of other things. That's what the current statute says. We have to follow this. But because what we're talking about here in terms of doing courts martial in the military, it's a state court. We are a state agency for these purposes. This is our state military code. So down there, beginning on page 5 in subsection B, we take out the references to this entire volume and only keep the punitive articles, which are the crimes. So we don't have to list them in our statute. They're already in this published volume of federal law, and we just reference it. And we take out the rest of it because we want this to follow state criminal procedure, because again, it's a state court. And that's clarified down on line 17 on page 3, where we added language to say we're going to follow the state criminal courts except as modified by this article, because there are some changes in terms of terminology. The next major change really carries on beginning at bottom of page 3 onto page 4. And that's where we again just focus on the punitive articles, so that we took out some of the language that talked about whether it's a greater punishment somewhere. And so that's that change. On the bottom of page 4, being on line 17, one of the other problems we had with the current military code, which again has been in place for decades, it was last changed in 98, is it didn't talk about how military defense counsel got appointed for those facing a court martial. So beginning on line 17 on page 4, we talk about military defense counsel being appointed at no charge to the person facing the court martial. So we clarified in our code what should have been in there from the very beginning. Moving on to page 5, we get to 1912-101, which talks about apprehension. That's the military term for arresting someone. And again, down there on line 13, you'll see on page 5, they talk about a marshal of a court martial. Again, that's not language that's been used for decades. So we just took that out.
Mr. Smith, can I back you up to the bottom of page 4 again, please? And if you could help me with, I understand the qualifications required of counsel shall include admission to practice law in Wyoming. Help me with the position of military judge advocate. Is that a bona fide attorney like yourself? Is that, what exactly is a military judge advocate?
Mr. Chairman, great question. So a military judge advocate is someone who's been accepted into the judge advocate corps, as I was before I retired. It requires you to be a licensed attorney in a state. Elsewhere in Title 19, I don't have it right in front of me, we say that you can be a judge advocate for the Wyoming Military Department as long as you are a licensed attorney in a state. The state judge advocate has to be a Wyoming attorney, but that was really so that we're not limited as to who we can pull in to be judge advocates. They go through training. There's a training course. They get qualified by the 3-star general I talked about earlier in DC. So it's a term of art. It means something in our statute, and it means they are an attorney. They just may not be a Wyoming attorney.
Okay.
But we have the added benefit or assurance that they've been through some training on how to do this, unlike just an attorney off the street from some other state.
Thank you for that. Please proceed.
Yes, sir. So turning over to actually page 6, we look at 1912-104, and this is really language about who can start a court martial, a criminal trial. And we wanted to differentiate. The military has always had, and our code provides for currently, 3 levels of court martial. The felony court is really what we call a general court martial in the military. The special court is kind of the misdemeanor court, no more than a year in jail. There's limitations on you can't have more than $1,000 fine. And then the lesser court, kind of the municipal court level, is a summary court, which is really administrative in nature. So beginning on page 6 on line 7, 1912-104 talks about who can start a court. So in A, we talk about general courts, and the current code says the governor or the adjutant general. It doesn't say or. So again, working with LSO, they said it should be either one of them, not both. So we put the or in there. On special courts, down on line 15, we previously, down on line 20, we talked about the commanding officer of a camp or encampment. And we decided court martials are important. We wanted it to be a general officer, not just any commander of any camp somewhere in the state. So again, we have, at any given time, we have 2 Army general officers, 2 Air Guard general officers, and then the tag, which can be either Army or Air. So we have 5 general officers. So again, we pulled it up to a level that really makes sense to me if you're going to start a criminal court against someone.
So, Mr. Smith, go ahead, Senator Anderson.
Mr. Chairman, I'm reading that differently. On page 6, it says a general court martial may be convened by the governor. And then it says, or a special court martial may be convened by the adjutant general. So it sounds to me like only the governor can do a general court martial and the adjutant general can do the others. But maybe I'm wrong.
Mr. Smith, is that a catch or what's the deal?
Mr. Chairman, Senator Anderson, it's the strange thing of changing an existing statute. So when you look at the existing statute, it says a general court martial may be convened by the governor or the adjutant general. Because they only added or after governor, according to LSO, you just put that line in there, even though the existing statute still has the adjutant general, but there was no change to it, so they left it out.
Mr. Chairman, so II is the adjutant general.
Mr.
Right,
Chairman,
have-
Senator Anderson, that's right.
Oh, okay, okay,
So Roman at I, okay.
yeah,
Yeah, thank you.
It's
Mr. Smith, is that good?
yeah.
Senator
yeah.
Anderson? So back, Mr. Smith, I had a quick question at the bottom of page 6, and sorry, this is something I want to make sure the committee understands as we go through. So a general officer, help me with that again real quickly. For just a layperson like me, a general officer, tell me who that is.
Mr. Chairman, a general officer is the highest of the officer ranks. There's actually up to 5 of them in the United States military, 5 different stars. It's someone who wears a star.
Gotcha.
So General Porter is a 2-star general. Senator Pappas, before he retired, was a 1-star general. So we have 4 1-star generals and 1 2-star general in the Wyoming Military Department currently. We do talk about it from that branch. So it would be one of the 2 1-star generals. If it was an Army member, it would be one of the 2 Army National Guard generals. If it was an Air Guard member, it would be one of the 2 Air Guard generals who could start the court martial.
Thank you for that.
Mr. Chairman,
Go ahead, Senator Anderson.
so what I was a spec 4 and I couldn't bring any court martials.
So you were not a star.
No,
Yeah, okay. Or I mean, you didn't have a star.
No, I didn't have a
But now-
star, and I wasn't a star.
Yeah, yeah. Well, you're a star
You're a
now.
star
I'll tell you
now.
that,
Yeah,
Senator
yeah.
Anderson. Go ahead, Mr. Smith. Thank you.
Thank you, Mr. Chairman. So on top of line 7, we talk about summary courts. And again, it's anybody of the above who could do any of the greater courts. Or, and again, the current code says the commanding officer of a company battery squadron. So we're talking a captain, maybe a lieutenant. And we decided again that that was just too low an officer to start a court martial. So we wanted to leave it to the promulgation of rules because we had some argument about what level that would be, but we wanted it to be something more than just a commander of a relatively small unit. A squadron can be around 20 or 30 people, for example. And then continuing on page 7, line 12, we wanted to clarify, because again, our existing code talks about summary courts, but doesn't really clarify what they are. So beginning on line 12 through 17, we clarified that a summary court is meant to be an administrative process presided over by a military judge advocate serving as a summary court officer. And that is the way the active duty does it. It does not require a judge, because a conviction by the summary court does not result in any confinement, does not kick you out of the military. So we're talking a reduction in rank, extra duties, restriction, a reprimand. So it's really just a way to handle administrative matters, a step up from some of the other administrative disciplinary actions we have.
Okay,
Moving on, sir, we get to page 8, and it's really the backside of that chart that we handed out. So in 1912 105C, we again had a fairly large change, because the existing code talks about a qualified military judge, or in the absence of a qualified judge, the county or district court judge. For years now, I've worked with some of the judges, particularly in Laramie County, where the bulk of our people are. And they, as this body has heard repeatedly over the last several years, they're inundated with court cases. So we wanted to take away a county or district court judge, because every time I broached the subject with the Supreme Court management of our judicial system, they were like, we're trying to get more judges. We don't want more caseload. So we basically provided here that the judge would be established by either under this article or by rules to be promulgated. And really there, we were trying to make it kind of future-proof, because we could say a qualified military judge, but currently the active duty is moving towards civilian judges. That wouldn't be a qualified military judge. They would be a military judge, but qualified military judge means a judge advocate who goes through specific training. So we wanted to put that in rules to keep it from having to come back to this body and change if that definition changed.
The general population judges do that.
so walk us through that paragraph one more time, Mr. Smith, because Senator Anderson, I believe that's my reaction too. That this is a pretty significant change that we're making here. Can you help us with it? Catch us up.
Yes, Mr. Chairman. And we entered into this, and again, we did these changes in consultation with the Attorney General and LSO. So these weren't done in a vacuum. We wanted to change this. Our first try at changing this paragraph was because county judges are no more. They're circuit judges. So that was wrong. So then when we went, and I had a couple of discussions with the Wyoming Supreme Court clerk, really, and we talked about caseload statistics, particularly in Laramie County, and the fact that circuit and district court judges don't know anything about courts martial. They don't know anything about some of the laws that are on the books for court martials, like disobeying a direct order. There's no civilian equivalent for that. And so there was a great deal of hesitation of putting a sitting civilian judge in that military environment, given the military code in the punitive articles. So the thought was to have it be a qualified judge, with the idea that it would be a qualified military judge, maybe from an entirely different state. It could be a retired judge. We talked about that. And so we wanted to put it in the rules because we weren't sure how to make this work. And we didn't want the statute to say something we couldn't work. But it was very clear that they did not want it to be a sitting county or circuit or district court judge.
So, Mr. Chairman,
Go ahead, Senator.
so
Anderson.
that could be a judge from anywhere that you'd bring in for a case or cases. You could bring them in from Ohio somewhere if you had the need.
Mr. Chairman, Senator Anderson, yes, in fact, within the National Guard and within the reserves of the United States, there are some qualified military judges. We don't have that slot in Wyoming. Some states have a slot for that, the bigger states that have a larger guard component, for example. So we could bring one of those people in. And our intent was to find somebody who was trained, because we certainly don't want to pay to train them just so they could do a court for us once in a blue moon.
So, Mr. Smith, go ahead, Senator Pappas.
Mr. Chairman, I just want to just state, yeah, it may seem like a big change, and I guess it is, but I see it as a very necessary change. Remember, the operative term is a qualified judge, and the rulemaking process will determine what those qualifications of that judge is, correct? So I believe that there will be promulgated rules that will define that, but taking out county or district court judges, I think is appropriate, because those folks don't have training in the specific situations that the military department deals with. And so I think it's pretty good language that will assist in actually getting the right people to do the job.
Thank you.
Mr. Chairman,
I'll let you respond.
Yes,
Senator
sir.
Pappas, and then we'll go to the good senator.
Mr. Chairman, Senator Pappas, one of the other things we were struggling with in talking with the Supreme Court administrative folks, I didn't talk to the justices, was this, our current military code makes it very clear it's a state court, but there is no provision as to who can preside over those kinds of courts, except for county and district court judges. So one of the reasons we want to put it into rules is we're going to have to get with the Supreme Court, who runs the judiciary, and find out what qualifications they will want for these kinds of courts. It could be a qualified military judge currently somewhere in the country. It could be they want a retired judge who's willing to sit on. Our initial contact with them, they were like, we've never heard of such a thing, even though it's in our statute. So again, we were trying to create enough flexibility to meet the need, but we're going to have to work to try to come up with rules to figure out what a qualified judge will look like.
So it's your intention to work very closely with the Supreme Court of Wyoming to promulgate these rules so that we know who a judge can be.
Yes, Mr. Chairman, and the way to look at that, we'll get to it in a minute. Every court martial, there is an appeal right. The appeal ultimately at some point goes to our criminal courts, existing civilian criminal courts, whether it be at the circuit level or the district court or even the Supreme Court, depending on the type of trial it is. So an immediate issue is, did the Wyoming Supreme Court say that can be a judge? So we have to, in order to make this work. It was one of the problems with our current code. We have to figure out a way that the Wyoming Supreme Court has signed off on, so to speak, as to who can conduct these as a judge.
Senator McKim.
Yes, Mr. Chairman. I think the word qualified judge is wonderful. It's like we're sprinkling fairy dust on it and we're going to magically solve the problem. The issue is, and it's been a while, but my understanding of the UCMJ, evidence rules are different. Testimony rules are different. The judge's leeway is different. The prosecuting a defense attorney is way different. So when we say qualified, I think we almost end up back to the JAG Corps. Or we take a retired guy and train him. But I don't see how you get there without that specific training. And I'm not trying to be difficult, but if you don't have that, I think a good defense attorney will eat our lunch in a civilian court. Like you said, what's failure to obey an order? What's
Mr.
failure
Smith?
to repair? What's AWOL? What's desertion? And that's where I'm kind of going with this. I think we should look at how we find a judge advocate general to come in for the courts. And I say that to protect y'all. Thank you, Mr. Chairman.
And Mr. McEwen was gonna, Senator McEwen was gonna say, don't you think? I think that was his question. No, good job, Senator. Appreciate it. Mr. Smith, what are your thoughts on that front?
Mr. Chairman, Senator McEwen, if you go way back to the beginning of the bill and we began the discussion, we are moving away from all of those, I'll say, different military rules of evidence, ways you conduct a court martial, and we are making it a state process. We will follow the state civil criminal procedure rules. We won't follow the military rules of evidence. We'll follow the Wyoming rules of evidence because this is a state court. The problem with the existing code is it made a mess because it incorporated all of those things you just mentioned. That is true of an active duty military court martial. They have their own rules of evidence. They have their own procedures. There's actually a script in here on how to do a court martial. But our state military code is a state military code. And so in our current code, we adopted the entire active duty military process for a state court, which is unusable because there's not a corollary. It doesn't work that way. So our whole point in this bill is to make it a state court following state rules of evidence, following state procedural rules, with the addition of not putting additional burden on our existing state criminal courts and keeping it more military centric with the idea that we would be able to train a judge to be able to do this.
Okay, follow up, Senator McEwen.
So when we get to the desertion or AWOL, those charges, they're not part of Wyoming statute. So do you understand? I guess I'm asking, how are we bridging that gap? Thank you, Mr. Chairman.
Mr. Smith?
Mr. Chairman, Senator McEwen, again, good question. We adopt, the current bill adopts the punitive articles of the UCMJ. That brings in all of those military-centric crimes you just mentioned. That brings them into statute if this bill is passed. So that creates a military, what we currently have, a military code of a criminal code in terms of the crimes. So all of those things are brought in, will be brought into the state statute. They're actually already brought in. If you look at the existing statute in Title 1912, they already reference the entire Uniform Code of Military Justice, which includes those punitive articles. So the change this bill makes is to take all the rest of it out, but keep the crimes. So we don't have to separately list them in 27 pages of statute, because the punitive articles in here are these with all the definitions and all the crimes listed. So rather than taking these and putting them in our state statute, we do it by reference. The other reason to do it that way is they do change from time to time. Perfect example is Article 120, which used to be called rape. It is now called sexual assault. It now has different levels of sexual assault that weren't in there 20 years ago. So we wanted it to be a living, breathing, doing it by reference allows us to keep up to the times in terms of military criminal code without having to change the statute every time it changes.
Okay, follow up. Go ahead, Senator.
Just one more question too. When a guardsman's federalized or put on active duty Title IX, at that point in time, do they become the responsibility of the federal force for court martials?
Mr. Smith?
Mr. Chairman, Senator McEwen, yes, if they go in Title 10, that's all right. Title 10 is active duty as we all know it. So the folks over at FE Warren are largely the people who wear a uniform are largely Title 10. When our folks particularly go overseas, there's actually a policy that says they can't go overseas unless they're in Title 10. They are subject to the entire active duty military code of justice. They can be court-martialed by the active duty, and they are out of our Wyoming control. The command and control immediately is when they go on Title 10 orders and they go to that deployed location, they are fall under that command structure. So it'd be just like those of you with military experience, it'd be just like you were when you were in the military on active duty at that point. But that's only when they go in Title 10. When they're coming to drill, when they're attending annual training, they are in what we call Title 32 status, which is under the governor and state control.
Mr. Smith, thank you. We'll move on here in a minute, but go ahead. Senator Pappas.
Yeah, I understand it affects Title 32. Does it affect any of the technicians or Title 5 folks we have?
Mr.
Smith.
Chairman, Senator Pappas, no, this is strictly for military members.
Okay.
And that's in our current state code. So a Title V civilian, which I now am, can't be court-martialed under our current or the revised state code. Some would say, sir.
Mr. Smith, I'm going to let you continue on through the bill, and we can always come back as we work it later. Senator Anderson.
I have one question, one
Hang
other
on,
question
Mr.
on
Smith, we do have
page 8, I believe we're on. That qualified judge, does he work all the court martials? There's 3 different ones. There's a misdemeanor kind of all of them. Do you have to have a qualified judge for all 3?
Mr. Smith?
Mr. Chairman, Senator Anderson, no. So the felony court, which we call a general court martial, requires a judge. The special court, which is like a misdemeanor court, up to a year in jail kind of thing, requires a judge. A summary court is administrative, and it just requires it to be a judge advocate, a lawyer to conduct it. And again, no confinement, can't be kicked out of the military. It's really it's a way for people to have their day in court, so to speak, without putting their career in terms of being kicked out of the military at risk.
So, Mr. Smith, at the college level, we called it a Title IX hearing, but go ahead. Please continue on through the bill for us.
Thank you, sir. Moving on to page 10. The next substantive is down on line 10 of the engrossed bill on page 10. And that was in our current code, it is very unclear about whether one can have a jury. So one of the changes we made in the military, we call a jury members of the court. So we have tried to change it back to jury. I think we might have missed one somewhere, but basically because that's the common term, right? That's what civilians understand. So down on line 10, we wanted to clarify because it is not clear in our current code when someone can request a jury. So line 10 through 17 is really talking about when an accused, somebody who's facing a court martial, they can ask for a jury, one can be appointed, and it'll consist of current Wyoming National Guard members of either service. And again, in the military, when you go to a court martial, it is usually officers at the installation where you are assigned who are your panel, your jury panel. So again, this was just to clarify because the current code is not very clear about when you can ask for a jury.
Okay.
The next major change occurs on page 13. Well, let me address down at the bottom of page 10 onto 11 and 12, 1912-106 talks about issuing subpoenas and warrants. So getting people to come to court as witnesses or the accused. And on page 11, again, we had some old language that didn't work very well. So if you look down beginning on line 2 on page 11, it talks about who can do a written order to appear before court. And it used to say the commander in chief, adjutant general, president of the court, or summary court officer may issue. The problem with that is our commander in chief is the governor. I'm pretty sure the governor doesn't need to be issuing orders to come to a court. The second thing is the adjutant general, the 2-star. If someone has said it's time to have a court, we don't really need the 2-star to order them to show up. We're in the military, orders mean something. So we changed it to the convening authority, which going back to our earlier discussion, for the highest level court, that's either the governor or the adjutant general. So one of them can order you to show up at court. The next level of court, a special court, it's a general officer. And then there's the summary court. You just issue them an order to appear. Or the appointed judge. Judges get appointed later in the process. So if the judge is in place, they get to order the person to show up. And that's a change that's reflected in this section on pages 11 and on to 12. And that's really what we're trying to do. The president of a court martial is the foreman of the jury. The problem with having the foreman of the jury subpoena or order people to show up at court, they only are in place if the court is occurring. It's kind of too late to be subpoenaing people to show up at the court. And once the court martial is over, they're done. So it just made no sense for it to be the president of the court martial. So with that, I'll stand to your questions before we move on to the next section.
Mr. Chairman.
Are we good? Senator Anderson.
Mr. Chairman, on page 11 there, line 21, you've got, it's crossed out down to subpoenas. And then subpoena is crossed out and subpoenas is written again. Is that, are we duplicating there?
Go ahead, Mr. Smith. We're talking two things. there,
Mr.
I
Chairman,
think.
Senator Anderson, now I have to go all lawyer on you, right? So subpoenas are what you give a person to show up at court. Subpoenas ducis tecum, which is the Latin, it means produce the thing. So it is what you do when you want somebody to give you a record or bring a, I don't even know, bring the safe into the court. I'm trying to think of how you, so basically there's subpoenas and subpoena ducis tecum. They're two different things.
Okay.
One's the people and the other's the things.
That line should have gone on across. Okay.
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 Please proceed.
I think we're basically at the bottom of page 13 on to 14. And again, we talked about on the top of page 14, we talked about jurors. It talks about members in the code. We're trying to change it to jurors because that's what we call the people that we're talking about. A fairly small change. On page 14 down at the bottom, we begin a discussion about fines. And this really goes on to page 15 and 16. And really the big change begins at the bottom of page 15 and on to page 16. The current code says that if you are adjudged a fine, let's say you're fined $500, if you don't pay it timely, the current code says you spend 1 day in jail for every dollar. So a $500 fine would result in 500 days in jail. That's ridiculous. I don't know what they were thinking back whenever they created that part of the statute. So on the top of page 16, we now say, if you don't pay your fine, the judge could order you to jail for 5 days if you don't pay it. So we get away from this ridiculous result where you could spend years in jail depending on the size of the fine. So again, it's just something in our current code that makes no sense. So we're trying to fix it here.
So, Mr. Smith, it looks like at the top of page 16 that you could have consecutive unpaid fines and then 5 days in jail. How long can that go on?
Mr. Chairman, we did not put any limit on that. The idea, based on my experience in the civilian courts here in Wyoming, you're basically in contempt of court if you don't pay the fine. You're usually hauled back in. They may throw you in jail. They may tell you you have to extend your probation. They may give you a set amount of time to pay the fine. But you can be put in jail repeatedly if you continue to disobey the judge's orders.
Okay.
There's no limitation on that. And so that's, this is where we came up with that language. It's 5 days every time you disobey paying the fine.
Okay, Senator McHugh.
Mr. Chairman, And once again, it's been a little while, but I think part of the fairness of the UCMJ, when they handed out monetary fines, it was based on weeks, days, months of pay. So my friend down there who was a specialist, if he got in trouble, his max fine could be $320, depending on which level of court martial we're at. Whereas if I got in trouble, it could be $5,000 or $6,000. And it seems like we're getting away from that. And I'm wondering, is it possible to include that back into this process?
Mr. Smith.
Mr. Chairman, Senator McKeon, it is included in the process. By adopting the punitive articles, it not only has the crimes defined and the definitions, it also talks about the maximum punishments. And the maximum punishments are based on grade. So just what you experienced or know about, I mean, do you personally experience? Let me rephrase that.
Nobody meant to assume anything.
Just like you had
Yeah.
heard that somebody once had to pay a fine. It is typically based on a portion of a month's or a drill pay based on your grade. So that would still be in here because we're adopting the punitive articles and it's part of that for each of the crimes.
Thank you for that, Mr. Smith. Please proceed.
Thank you, sir. So again, when we talk, beginning on line 9 on page 16, we talk about immunity. And again, we tried, you'll see in the section 2, we took out the current subparagraph A and C because in B, we changed it so it isn't just about felony crimes, it's any crime about immunities. This is really about if the county sheriff or the local police department shows up at the gate of the military facility, at the door of the armory somewhere in the state, this basically says with a warrant for the arrest of somebody, we will surrender them to that lawful authority. A and C in the current code got really complicated. And that's really all we're trying to do. We're just trying to say that if there's a crime against the laws of Wyoming or any political subdivision is alleged to have occurred by a member of the Guard, if they bring us a warrant, we'll be apprehended on the base, for example, and surrender to the proper civilian authorities. And, you know, during my years at the Wyoming Air Guard over at the airport, we did this on a semi-regular basis, more often than you might think, where somebody would come to drill on a weekend and the Cheyenne PD or the Laramie County Sheriff would come to the gate and say, hey, I hear this guy or gal is around. I have a warrant for their arrest. And we would leave them at the gate, go get the person, escort them to the gate, and they would there be arrested and taken away. And that's really all this is talking about.
Okay, questions? Please continue.
Thank you, sir. So we're almost there.
Closer.
So on
Closer.
page 17 and 18, we get into 1912-110. In the current statute, this lists a variety of crimes. It adopts the punitive articles already, but it also lists a bunch of crimes. So what we did in 17 and 18 is, you'll see in section 2 when I talk about the sections being repealed, we took that separate listing of crimes out because we already adopted the punitive articles listing the crimes. But there were 2 provisions of the existing code that were not in the punitive articles of the UCMJ. Since the legislature put those in our military code, we left them. But we had to separately list them because they weren't in the punitive articles. The first one on page 18, you'll see it's about a member of the Guard being tried and found guilty of the offense of using contemptuous words against the president, vice president, member of Congress, secretary. Again, this is in the current code. The difference is the current code talks about an officer. When you look at 1912-110A, it talks about members, and then the subparagraph talks about officers. So literally, the discussion with LSO in the Attorney General's office was, well, it should just be any member because that's what we're talking about here. This is actually part of the punitive articles of the UCMJ regarding a commissioned officer. So this does expand it to any member of the Guard. And then because we took out so many of the other provisions, we had to add the punishment for this offense since it's not in the punitive articles. The second one is down beginning on line 19 on page 18 and on to page 19. And this was a source of much discussion on the House side. At one point during, I think, the second reading, there was an amendment to take it out. The issue there is this is an existing part of the code. It's been in there at least since for the last 22 years. I don't know when it was added. I tried to do a little research. I couldn't figure it out. So it says any member of the Guard who resists or aid in the resistance of a lawful process in an area declared to be in a state of actual or threatened insurrection, that's number one, or who aids or attempts the rescue or escape of another from lawful confinement or custody or confinement, that's two, or aids in resisting any force ordered out by the governor to execute the laws to suppress actual or prevent threatened insurrection or repel an invasion. So those are the three situations where we are saying that our Wyoming National Guard members can't do that stuff. There was a lot of discussion, and certainly Chairman Burkhart and Representative Stivert can talk about what they heard during the second reading on the House. And it failed as an amendment to take this whole section out. From the military department's perspective, our concern is we all raised our right hand. We all swear to support and defend the Constitution of the United States and the state of Wyoming. We all agree we're going to follow the orders of the governor and those put over us. Someone aiding in someone escaping custody or aiding in insurrection, which by its very definition means it's trying to overthrow the current government, who is a military member, that's a big deal. It's a big deal to us in the military. Because one of the hallmarks, as you all know, of the American experience, so to speak, is that the military is always under civilian control. We don't do coups in this country, thank God. And we never want our members to think it's okay to be part of something that threatens the stability of the current government. So I personally feel very strongly about this particular section. And it was defeated in the House, so it's part of the engrossed bill, because I think this is very important that we've never used this provision in the 20-something years I've been around, 18 and a half. But I think it's just fundamental to what the National Guard is all about. So that was a section of much discussion. I think because these days the word insurrection is kind of a hot button nationally. So I think that was some of the concern by our good representatives, just being concerned about what are we doing here.
Okay.
So with that, I'll stand for questions because this was a fairly controversial provision.
I think Senator Anderson.
Mr. Chairman, that insurrection goes back to 1892 when we had an armed invasion of the state. And a certain author wrote about it being an insurrection, but the military didn't handle it as such.
That's something about Johnson County, sir? Is that what you're
Yeah,
talking
something
about?
like that, yeah.
Yeah, where the good senator was born. By golly. Yeah, there you go. He knows.
Insurrection, yeah.
Okay, well,
Mr. Chairman, I
Smith,
believe
I'm gonna
I've-
let you finish up the bill and we'll keep
Thank you,
moving on
sir.
through the night.
Well, and I apologize for
Long
how
day.
lengthy this
I
gets.
thought he was done.
So section 2, you'll see three parts of the current code that are repealed. And in my chart, I tell you about that, what those are. So 1912-104, it allowed too low an officer to start a court. So we kind of talked about that already, but it repeals a specific section. The 1912-109 has to do with immunity and the service of process by civilians. So because we changed B, we can take out A and C because B covers it all as modified. The final section we just talked about is the 1912-110, and that are all the sections about the specific crimes that the current code lists. And we're now doing it by reference to the punitive articles. So those are what are repealed. And then of course it's effective July 1st, like most bills. With that, Mr. Chairman, I stand for your questions, further questions.
Thank you, Mr. Smith. Questions, committee, anything? Not smart enough. Okay, yeah. Thank you, Mr. Smith. General, Senator McEwen, go ahead.
My question is, does not every guard member have an 05 in their chain of command before they get to a general officer or at least a senior major? And if so, would we think about powering the summary court martial down to at least that level? It seems to me that having a general officer proceed over a summary court martial is pretty extreme. Thank you, Mr. Chairman.
Mr. Smith, what are your thoughts on what was the thinking with regard to the summary court in that circumstance?
Mr. Chairman, in answer to Senator McEwen's concern, if you look at the bill back on page 7, which is 1912-104, subparagraph C at the very top of page 7, we talk about summary courts, and we say any person who convene one of the other courts, which would be a general officer, or any other person designated in the rules promulgated, with the idea that we were going to push it down to a level. We just couldn't decide what level that was. So we were going to put it in the rules because we didn't want summary courts to be, as it currently is in code, the commanding officer of a company, battery, or squadron. That just was too low because it could be a captain. Nothing wrong with captains, nothing wrong with junior majors, but we wanted to do that in the rules so that we could maybe talk about the slight variation between the Army Guard and the Air Guard, because we're organized differently.
Mr. Chairman,
Senator McEwen.
it's just kind of the wording in the bill that has led me astray a little bit. The fine structure of $750, $250, $500, $750, and $1,000 really didn't imply to me that that was based on a rank structure. And this kind of leads me to believe that it had to be a general officer or somebody appointed there. So I appreciate your answer, and I think I got a better understanding where you're trying to go with it. Thank you, Mr. Chairman.
Thank you, Senator.
If I may
Mr.
follow
Smith,
up, Mr.
Final
Chairman.
thoughts, you bet.
To that end, only the punitive articles all talk about fines in terms of either a maximum amount or by grade, a reduction in grade, for example. The two provisions that we just talked about at the very end of the bill that are not in the punitive articles, that's what's in the current statute. It just shows as a change because it got moved because we consolidated it. So if this legislature wanted to change the way that word is worded, they could. We weren't trying to change anything. We were just moving it around.
Thank you, Mr. Smith. I want to move a little bit, General. I want to give you an opportunity for any thoughts. If you would not mind sticking around, obviously, and we can ask questions of the military a little bit later. I want to try to get to folks who have been here, including our brethren from the House. And Representative Stivard, give us your thoughts on this bill, please, before we go to public comment.
I want to thank Colonel Smith, retired Colonel Smith, for presenting this. This is a hard bill.
Yeah.
I think it's a good bill. It needs to be done. So
Appreciate your work on the House side, Representative. And Chairman Burkhart, I want to give you an opportunity for any thoughts, and you'll have an opportunity later as well. But
Thank you, Mr. Chairman. I think Mr. Smith summarized everything well. Those last two paragraphs at the end of the bill were contentious on the House side. Ultimately, the House declined to remove them and left them in there. The last one on insurrection and that was actually, I understand, put in by the legislature more than 40 years ago. when you consider what was going on in the country at that time, was put in then, but the House declined to remove them. Frankly, I thought from the debate they would. And in the end, it was left unchanged. So just
Okay.
that was the discussion on those. That was, those two were the big points in the House. I think they stayed fairly intact in the bill is what it came out of the interim committee. So with that, and again, quite a bit of legal discussion in the bill. The lawyers in the House, the attorneys beat up on it pretty good, but you have what you have in front of you is the engrossed bill.
Any questions for the chairman? Again, really appreciate it, gentlemen. Thanks for sticking around.
You bet, Mr. Chairman.
And thanks for your work on the House side. I want to go to public comment on the bill. And before I do that, ladies, please take a seat, but I apologize. I've been wanting to squeeze in an opportunity to recognize Senator Ellis, who has been here throughout the explanation of the bill. Senator Ellis, do you have any comments you'd like to make at this time, or you're welcome at any time that you're here. Just get my attention. Appreciate you being here. Welcome, ladies. Appreciate your patience. You know, this is important stuff that we're walking through this evening. Please introduce yourself for the committee and welcome.
Thank you, Mr. Chairman and gentlemen. I'm Rachel Bennett.
I'm Marilyn Burden. We're both former members of the Wyoming Air National Guard.
Take it away.
Okay, I think that, excuse me, retired Colonel Smith did a great job summarizing a lot of really complicated things. And I think there are still some questions that I have, and actually they weren't listed in his summary, and he didn't actually comment on that section. And I don't have line numbers on my sheets that I printed, but
That's
it's
okay,
writ-
Ms. Bennett. Maybe by reference to whatever statute,
Okay,
numbers
and
of
I think I
statute or
can
whatever,
direct
we can
you.
find it.
Okay, I think I can
And,
direct you. Oh,
And I would
okay.
ask, ladies,
Thank
what
you.
we ask of the military folks and our House counterparts is to stay up
Oh.
within 4 or 5 inches of
Okay.
that microphone for us. Thank you.
Okay, thank you,
Okay.
sir. And I also wanted to mention, I did watch the committee meeting that was held November 30th of last year, which encompassed members of the House and the Senate that lots of faces changed. So the committee sponsorship of this particular bill was done by a group of people that was the majority of a group of people that wasn't you guys. So I can see why there would be some questions. And also in that committee meeting, I believe General Porter noted that there hasn't been an arrest, effort with this type of UCMJ provision, Wyoming statute, since I think 1963. So I don't think it gets used very often, and that's good. But I think discussion about it nonetheless should be really focused and specific. And so I'll try to keep what I'm here to talk about, simple. So in the very beginning, 19-12-101, section B, and it is
And that's going to
it's on
take us to
page
page 3,
three.
committee.
page, page 3. And it begins what I'm focused on is the section that would change in line 11. Any member in a state, and it takes out active duty status. And it's basically a state duty status, including a status under Title 32 United States Code or active state service status. The only reason this is concerning to me, and because it does have to do with a matter of jurisdiction of the status of the member of the Guard. And since this came up earlier tonight, about who's Title 10 and how some of these types of terms can get confusing, especially with different variations of the UCMJ involved. This particular bill can be confusing because there's references to things that already exist in the UCMJ, which answer some of the questions that I had. And there are parts of the UCMJ that address people who are active duty in Title 10. And then there are parts of the Wyoming statute, for example, where we talked about at the end of the statute when Mr. Smith was talking about it had said officer, now it says member, who might use, foul language about an elected official or the president. So the type of term we use when we're talking about a person in a status can get kind of confusing. So, and it should be specific, especially if we're talking a person's freedoms could be taken away and charges filed for an infraction or a criminal offense. And so I just wanted to know where I would request there be some clarity to that and some specific clarity to that section, because at a time frame where some of you may not have been on the Transportation and Military Affairs Committee in October of 2019, Senator Hutchings had asked Mr. Smith to present to the committee some explanations of different terminology used for different statuses in the Guard. And while you guys don't have this handout with you, I just brought it to illustrate. It's a 10-page slideshow that explains different statuses of employees. And with that type of explanation, it makes it easier to understand. And in this slideshow, it talks about there's active Guard reserve members who are the Title 10 that Senator McEwen was talking about, and also that Mr. Smith referenced as, holding up the UCMJ and saying everything that's in the UCMJ applies to Title 10. Well, in this particular regard, I think he says in this slideshow, at least in October of 2019, there's 220 Army National Guard AGRs and 254 Air National Guard AGRs. So the UCMJ applies to them like it would active duty members. Having retired from the Guard and having previously been what's referenced in that particular paragraph, a Title 32 employee, there's been a lot of, I guess you'd say, confusion about that type of employee. Because from a personal experience and having been part of a situation where there's some debate, not just from like a military standpoint, from a civilian standpoint, a Title 32 employee is the person who's some of the time a civilian and some of the time a military member, but they can't have their civilian job without being in the Guard. And so with the way that this particular line is worded, I would just ask that, similar to what maybe the state of Colorado does, and I think Montana does it, is that at the beginning of a particular bill that might have some confusing terminology or some verbiage that, even if it's not new, is potentially cause for confusion, that there be some definitions at the beginning of the bill to clarify when we say state duty status, to specify, does that mean all of the different 4 types of statuses that an employee might be in? And while in some ways that might go without saying, because in some places it gets glossed over, that we say, oh, it's when somebody's on orders. Does everybody know that that's what that means? And I only say that if there is the possibility to have a gray area of a confusion with it, then, and I know, like I say, from personal experience, that there has been a lot of gray area as what applies to civilians, Title 32s, and what applies to a person who, if they wear a uniform, but they're also a civilian, how that applies. There's a lot of gray areas that's still in debate. And so I think if there were some defined terms that reflected what that exactly means, so that if there were ever a place there could be confusion or a gray area, that there wouldn't be such a gray area, and it might not be used in an inappropriate, jurisdiction, as it pertains to a member, where it wouldn't apply and more time and effort gets spent on muddy waters of jurisdiction than on applicable members that this actually applies to, is my request with that piece. Thank you, Mr. Chairman.
Thank you, Ms. Bennett. Appreciate that. Committee, questions or thoughts for Ms. Bennett? Okay. And Ms. Burton, do you have anything for the committee tonight?
Yes, sir, Mr. Chairman. As Mr. Smith was going through this, I had a couple of clarifying questions. Would it be all right for me to ask those questions of Mr. Smith? There's I have two of them.
Why don't you let us know where it is, and how about the committee will ask him a little bit
Okay,
later?
thank
Okay?
you. I've never done this before, so
You're
it's a
doing great.
learning process.
No problem at all.
Okay, on page 8, section C, there was quite a bit of discussion about that paragraph. And so I know from my time in the Guard that literally when something happens, the status drives everything, as Ms. Bennett was talking about what you can do with a civilian. So on this section, how does this impact active Guard reserve members? Would they still fall under the state? Would they fall under the state process or under the federal process because they're Title 10? Because Mr. Smith referred to military members, but there's two types of military members. There's active Guard reserve Title 10, and then there's drill status guardsmen Title 32.
We'll make sure that we clarify that. Okay.
All right.
Marilyn, you said you had another spot for us.
Yes, sir. On page 10. Paragraph K. So it's talking about the requesting of the jury or members of the jury. It specifically says that they would use Wyoming National Guard members of either service, but you could use active duty or reserve members. So my question is, would the defendant have the ability to ask for active duty or reserve members if they had a perception that they may not get, that they might be prejudged or they wouldn't necessarily have a fair jury or an unbiased jury? Would the defendant be able to request members of the jury that are outside of the Army or Air National Guard? Those are the only questions I have, Mr. Chairman.
Thank you for that question. Committee, anything for Ms. Burton tonight?
Nope.
Marilyn, thank you. Anything else, Ms. Bennett?
No, Mr. Chairman, I just thank you for allowing us to have the chance to come in on our thoughts.
It's absolutely terrific of you to be here and to stay with us and to be patient. And we appreciate your feedback and your testimony. Okay, thank you very
Mr.
much,
Chairman.
ladies.
Thank you, Mr. Chairman.
Thank you.
Thank you, committee.
Okay, I don't think we have anybody, Mr. Vice Chairman, on the waiting list on the Zoomy front. Do we have anyone else in the room who would like to testify on the bill tonight? Okay, I'm going to ask General, would you be willing to come back forward and bring anybody with you that you'd like to have alongside? Committee, this is our chance to have one final round with our military brethren here. General, there was a question on page 3, and Mr. Smith, I'll take you to page 3 on that because it sure seems relevant. Clarity with regard to that state duty status and the fact that we strike active, and I want to make sure the committee and I understand that. Can you run through that for us a little bit? Thank you.
Thank you, Mr. Chairman. And it's a great question. One of the problems of, as you all know, with dealing with a statute in a title like Title 19, which is large, is some of the terminology in this bill is actually defined elsewhere in Title 19. I don't have all of that in front of me. I thought I brought the entire Title 19 with me, but I don't have it at the moment. But I will say a couple of things based on Ms. Bennett's question, which is a good one. First of all, in the National Guard, what we call AGRs, which is one of the 7 statuses we deal with, active guard reserve, they are actually Title 32, not Title 10. So that's a common misconception even among our own people.
Can
When
you
I
state
said that
again?
they,
Mr. Smith,
Sir.
can you state that again for me? Active?
AGRs, which stands for Active Guard Reserve, is a status. They wear a uniform. They are on orders all the time, 24/7, whatever their period of orders are. For example, I was on AGRs for over 18 years,
But they're not titled.
but they're not Title 10. It's under 32 USC 502, actually. So AGRs fall under the state military code currently and would under this bill. The problem is the term AGR is actually used in the reserves and some of them are in Title 10, so it gets really confusing. But for purposes of this bill and the Wyoming National Guard, AGRs are Title 32. When I said they are subject to the code, if I stated it wrong, I apologize. Because they're on orders 24/7, so they don't show up for drill weekend on orders, they're always on orders. That's what I meant, that the code applies to them all the time, just like active duty. For our drill status guardsmen, what we laughingly say was the 1 weekend a month, 2 weeks a year, and we kind of laugh because it's suddenly become like 2 months a year. But for them, only when they come to drill or to annual training are they on orders, or as we say in the statute, in a state duty status. So they're in the military under the governor's control under Title 32. Not civilians, because they're never in a duty status. Now, this gets really confusing. And again, I can share with the committee after this, I can provide them where some of these definitions are in Title 19. I just don't have it in front of me. I thought I had something that showed me. So active state service and state duty status mean something, because we also have a status called state active duty, which is when the governor asks the Wyoming National Guard to provide help to the state. The common example, there's flooding in Saratoga. We put 40 people on to help sandbag and protect the town from the flooding. Those are in a state active duty status, which means the state is paying their bill. This is where it gets really confusing. So an AGR in a Title 32 status, the federal government pays their bill, but they're under the custody and control of the governor. Same with people who come to drill or annual training within the state. They are paid by the federal government, but they're under state authority. So the code applies to them. That's why this language may not make a lot of sense in a vacuum, but according to LSO, this is the way you do it. So I defer to the questions of the committee on the duty status issue.
Mr. Smith, thank you. And you can tell from all of us up here, you can see the wheels turning, because we have to take this product out into the chamber. And so appreciate your rundown, and that's going to be a little bit of a tough lift, I know. But Senator McEwen.
Thank you, Mr. Chairman. Once again, it's been a little while. But my question is, and I think we haven't hit upon, we've covered M-Day soldiers, we got AGR, we have all that covered. What about technicians? We got a guy running around in a uniform and he's on a GS pay scale and the uniform's almost decoration. Is he a civilian or a soldier at that time?
Mr. Smith.
Mr. Chairman, Senator McEwen, as you well know, the answer is they're a civilian employee. So with our Title 32, what we call dual status technicians, during the week that they're not on military orders, they look exactly the same as if they're on orders. They wear a uniform. It's a requirement for their civilian employment. They have to maintain their membership in the Wyoming National Guard. And they then also go to drill weekends. So, but a technician, say Monday through Friday, wearing a uniform is actually a federal civil servant. So that this code does not apply to them, even though they're wearing the uniform during the week. If they're on orders, if they're doing a day of annual training or an inactive duty training status like a drill weekend or a makeup for drill weekend. So literally, if a dual status Title 32 technician does something wrong, commits some form of misconduct, we literally have to look at that moment in time. What was their status? Were they in a federal employment status? This code wouldn't apply. Were they on some kind of orders, making up a drill or doing a day of annual training? Then the code would apply. Same person, same misconduct, two different results, depending on their status. It's a wonderful world of being an attorney in the Guard. This is what makes it interesting.
I think your reference of that kind of employee, military employee, is what Ms. Bennett was alluding to, correct? Yeah. Follow up, Senator Pappas, let's go to you.
Chairman, it just to make sure everybody understands, they can be on Title 10 if they're called to duty. So all of those statuses can change. So that even makes it more confusing, especially like when we deploy people out of this country, they tend to be all in Title 10, don't they?
Mr. Chairman, Senator Pappas, everyone who deploys outside the CONUS has to be in a Title 10 status. That's a Department of Defense rule. And I can tell you about why it's there, but I won't bother.
Mr. Smith, I'm gonna exit the scene right here and go, I want to go to page 10, I believe it was, where some of our folks who testified publicly tonight had some questions about paragraph K on page 10. Would the defendant, and I don't even, would there be any ability to request a particular kind of jury? I think was the question there.
And Mr. Chairman, Major Burden, Marilyn Burden brought up, it's always an interesting question. So in the current code, and in the code as could be changed by this bill, the answer is no. Like in a civilian criminal court, you don't have the right to pick who's going to try you, who the jury is. What you do have an absolute right in our code as it's modified or in a civilian criminal court is to question the jury to make sure there is no fundamental bias by that jury member. And that's part of the court martial in the criminal court process. You what we call voir dire them, again, a Latin phrase where you basically look into what their story is. And you can ask that person to be removed by the judge if they show a bias or are known to have a bias. So just like in the Wyoming criminal courts, you don't pick your own jury, but you do get to make sure the jury is fair and impartial and not have a previous bias. And that is what we intend to have happen under our military code.
Okay, thank you for that. Committee, that understood. Mr. Smith, I've got just an overall 30,000 foot question, and I'll try to not fumble the ball here, but it's unfortunate, but we've had lots of headline makers over the last handful of years. And I do have constituents who have asked in a casual sort of way, are we doing okay on that front in Wyoming? Fortunately, I think we are, but are we confident that this is going to get us to where we can get to justice in a good and better way? I guess that's really what I feel like this represents, is a little bit more streamlining, a little catching up. Where are we at with things from a 30,000 foot view?
Mr. Chairman, I'm sure General Porter has lots he would say on this too, but the problem we currently have in I think Ms. Bennett mentioned it, we have not done a court martial since the 60s. It was actually of the tag for a travel voucher fraud of all things. which I know Senator Pappas knows what a travel in Senator McEwen. So it's kind of funny. That's the last court martial in Wyoming. Mainly because in the last several decades, our code is so out of date, it is literally unusable. There's so many holes that we're trying to address here in this bill that we can't court martial anybody. Now, some would say, oh, good, so you can't whack your people harder. But there is a problem with it. Because we can't do, say, a summary court, we have certain administrative processes. For example, something called an Article 15, which is out of Article 15 of the UCMJ, which is a non-judicial administrative action for the more serious misconduct cases. We give the member, so we offer it to the member. The member has the right to say, no, I want to be court-martialed. We can't court-martial them. So we're left with doing a lesser form, like a reprimand, and then typically trying to administratively separate them because we don't have the intermediate ground. We can't take them to a summary or a special court where they can have their day in court in front of an impartial jury represented by counsel and tell us why they think they didn't do what we think they did. We can't do it. Our code is broken. So in a sense, our current code doesn't allow us to handle people in a way that could protect their careers. We're left with doing things that either are so low level that it's not justice, or we can only try to kick them out of the military, which maybe that wouldn't have happened if they actually got to go to a court and present their full case. So for me, that's our problem with our current code. Our hands are tied in terms of making sure justice is done. There is another example I want to give. Most recently, we had a case of sexual assault alleged. It involved a civilian victim and one of our military member as the alleged perpetrator. Because it happened in a room, it was a he said, she said case. Anybody who's familiar with criminal prosecutions knows those are horrible to prosecute, especially in the sexual assault arena. Everybody wants to protect the victim, but a lot of times the facts are hard because there's no eyewitness. Our local district attorney in that particular case made a judgment, totally their call, to not prosecute that case. If we had had the code as presented in this bill in law, we could have done a court martial for that member and let him have the day of court and let the victim have the day in court. Because our court martial process is so broken, it's unusable, all we could do is take him to an administrative separation. And I can't comment further on that because that whole thing is still pending. But it just was wrong. If he didn't do it, he deserves his day in court. If he did do it, he certainly deserves more than being separated from the military administratively.
Thank you for that. General, I want to give you an opportunity to make any comments you have about this bill and the status of everything.
Yes, sir. Hey, thank you, Mr. Chairman. I don't have much to add after all this. It's been very in-depth. Mr. Smith covered really I think the trigger point for us was this most latest case that we really were left without many good choices. And that was what drove us to try to get this code updated. Obviously, it's not something we want to let languish for another 20 years and not continue to update. It needs more maintenance than that. And that's why it is such a heavy lift and it's such a struggle to get everybody to understand the details of this. But I will tell you, it's largely due to clean up the process to make sure that we can actually execute or conduct a court martial here in the state. The final thing I will add is, except for the summary level of court martial, none of this stays in the military department. It is all appealable either to the Supreme Court or the governor himself. So it's not like, I think, that the military will have sole jurisdiction on this, except at the very low level summary court. The rest of that is all appealable up through the chain. And Chris, I don't know if Mr. Chairman, I don't know if you like that, if Chris would expound on that anymore, but that seems to be a little bit of a concern too, that this may have that effect of being able just to punish people on the inside.
Mr. Smith, go ahead. And I think
And I'll
that
be
is,
qu-
that
go
is important that we remind everybody there's an appeal process and we do have that opportunity for the accused. Absolutely.
Mr. Chairman, and I apologize, I meant to highlight that. It's largely on page 9. On page 9, line 6, for example, it says the governor actually will review every conviction. Nobody will be dismissed from the service or discharged until approved by the governor. And then it says the governor may suspend or set aside all or part of a sentence as he sees fit. But beyond that, it then goes down into new paragraph G on line 13. And if you go to a general court martial, which is a felony court, like a district court case, it's appealable to the Wyoming Supreme Court, just like every district court case currently in Wyoming. On H on line 20, we talk about summary and special courts. That's appealable to the district court of the county. And then if they don't like the district court result, to the Wyoming Supreme Court. So and that's in the current code. We fixed it to help some of the language, but that's always been in our code. And so this doesn't change that.
And then you get into the part of the world that our colleague in the Senate lives in her regular job. And she's been here tonight and has a couple of questions, and she's welcome from our standpoint to ask them. So Senator, go ahead.
Thank you, Mr. Chairman. And this is a little unusual. Thank you for the latitude to ask a few questions.
You're welcome.
I appreciate on page 7, I did have a question about the summary court martial, the administrative hearing that you have. I understand the conviction is not a sentence or considered a criminal conviction, but is there any instance I just want to understand how this works. If you rack up a certain number of those disciplinary actions, though, that start giving rise to like a more serious offense, can those be considered in your other proceedings in your felony or misdemeanor type level courts? And I know you use the term general and special, but I was just curious how that works.
Mr. Smith.
Mr. Chairman, Senator Ellis, great question. The summary court being administrative is very limited in what it can do. You could go to there's nothing in our code, there's nothing even on active duty in UCMJ that doesn't say you can't go to 20 summary courts in the history of your military career. The reality is when most people go to a summary court and are found to have committed whatever misconduct is being addressed, if they continue to have misconduct problems, if it rose to the level of serious misconduct, we would take them to one of those higher level courts. If it didn't, it was just that low level failure to obey orders, depending on what the order is, some of it can be very serious, failure to show up for as ordered to duty, we would probably administratively separate you. We have a variety of tools to impact your military career for the lower level summary court kind of offenses, where we're really not talking about strong criminality to the offense. It's not a sexual assault. It's not an assault. It's not a bribery. It's not, helping someone escape confinement. It's you didn't show up for work on time. You failed to obey an order from your NCO, your supervisor. That level. So I'm not sure if I'm getting at your concern, but there is nothing in the code that says you couldn't go to multiple summary courts. It doesn't escalate on the second one or the third one.
Follow up, Senator.
Thank you, Mr. Chairman. I guess I'm thinking of it more as like a prior conviction. Are you showing a habit or that a particular individual demonstrates subordinates? You routinely tell them they need to do this and they don't do it. You tell them to do something, they don't do it. And then all of a sudden you start getting an issue that's escalated. Can you look back at those prior proceedings when looking at it in a more elevated setting?
Mr.
Go ahead,
Chairman,
Mr. Smith.
Senator Ellis, great question. We talk about progressive discipline in the military. Depending on what the offense is, if it's super serious, there is no progression. We're going to kick you out. We're going to take you to a court martial. But if you're having trouble fitting into the military, you're having trouble showing up for work on time, you're having trouble showing up for drill weekends, you're not completing the training assigned to you, we would take a progressive disciplinary approach. already we have the ability to do multiple levels. So typically we talk about a verbal counseling, the kind of thing you see in the civilian world. Your boss hauls you in and says, hey, cut that out. That's what we call a verbal counseling. Then there may be, it keeps happening. So now you're going to put it in writing. That's a written letter of counseling. Then there's a letter of admonition. Actually, we don't use that much. It's one above a letter of counseling. Then after that, it's a letter of reprimand. If a letter of reprimand doesn't get your attention, I know on the Army side in particular, we have a general officer letter of reprimand where you actually have to go see the general and tell them why, and he tells you why, he or she, why you screwed up. If that doesn't get your attention, now we have an Article 15 where you can actually lose rank, be fined, and depending on who gives it to you, it gets really complicated. They can't kick you out. They can't send you to jail. So we have all of those steps. And then if it's still a problem, we would have the active duty has court martials. We currently can't do anything because our code's broken.
One last
Senator, go
question.
ahead.
Thank you, Mr. Chairman. My last question for some crimes, and I'm going to use sexual harassment as one. It's not always an isolated incident that happens. It's usually, anyone who brings those claims has to show a pattern of conduct so that it's not an isolated incident. But then we heard earlier how whatever law guides depends on whether or not you were wearing a uniform that day, whether or not you were on orders. And so it gets really messy when you start looking at, well, maybe it happened Monday through Friday when I was in my civilian capacity, but on the weekend, there was also conduct. How does that get resolved? And I'm also a little bit curious on which is controlling, because for those kinds of incidents, maybe you've got a person that brings the claim and they're adamant that, the UCMJ should apply versus this code. How does that get resolved? And I'm just trying to get a better sense of how that works.
How does the split status work when
Yeah.
there's an accusation?
Yeah, Mr. Chairman, Senator Ellis, another great question. This is what makes my job so complicated. So every time we have an indication of misconduct, we usually investigate it. We appoint an investigator. They should be neutral, detached. If it's a very serious matter, we'll bring somebody from outside the state. So they have no biases. They don't know any of the players. They then, as part of their investigation, will determine exactly the when and where. We have had occurrences along the lines of kind of what you're saying in the sexual harassment area in particular, where we've had to take actions on both sides, so to speak. We've had to take the federal employee and go through the federal employee discipline process. There's a right of grievance, there's a right of appeal to various agencies. And then at the same time, we've had to also address additional misconduct that occurred while in a military status, which is what this code talks about. So literally, where you have a course of conduct that comes to light, you could face multiple disciplinary actions. You would never be hit twice, so to speak, for the same crime against the same person at the same time. It all depends on your status at the moment the offense occurred. And we've done that. We've had people get reprimands on the civilian side, reduction in grade, and then on the military side, get a reprimand, lose out on a promotion.
Mr. Chairman.
Go ahead, Senator.
Just as a follow-up, I just want to make sure I'm understanding. So you maybe have two courses of action. Can the federal side look at what's happening with the state side when they say, in talking about building that culture of hostility for a sexual harassment claim, do they look at each other to see, it wasn't just these incidents where, I had my uniform on, it happened 3 times, but it happened 6 times when I was wearing my civilian outfit. Are they able to look at what's happening in those dueling proceedings?
Mr. Chairman, Senator Ellis, I was talking about the consequence to the actor. In terms of environmental stuff, we really don't care about status. So if you have an office, I've worked in offices with people in 5 different statuses. All of them could do the exact same thing, and all of them would be addressed disciplinary wise differently, but all of them in that atmosphere would be addressed. We spend a lot of time, I know General Porter probably wants to talk on this. We spend a lot of time trying to train our folks on what's appropriate. And it is based on what is appropriate and not appropriate given our sexual harassment guidance and laws. We don't care what their status is, except when we get to the point of needing to discipline somebody.
Thank you.
So-
Thank you, Mr. Chairman, and thank you for answering my questions. I'll leave the dais so there's no confusion about my role here.
No, you're very welcome. Thank you, Senator. Good questions. And I think the idea is we're just wondering about subsequent actions. And can you look back if it's been across the fence, in a different sort of jurisdictional way? And I think the answer is yes. You're going to be aware of somebody if they're repeating behaviors, even if they're in a different status, right?
Mr. Chairman, mostly. How's that for a lawyer answer?
Mostly, there we go.
So depending on let's say we're in a court martial, because that's what we're really talking about in the code. In a court martial, if they're found guilty of committing a crime, you've turned to sentencing. In sentencing, the person who's now been found guilty can put on that they're a really good soldier. They've always done great things. They can put in evidence, letters of recommendation, commendations and decorations they've got, records of all the training they've done and they've excelled at, to try to say this was an aberration. Similarly, the government can put in, he's been dinged 5 times for the same thing, and that can heighten the disciplinary action at that time. The reason I say mostly is we really, for the same person, we have to draw a firm line between the different statuses. So in a military, say, court martial, we can't bring in the civilian employee disciplinary actions. In a civilian employee disciplinary action, we can't bring in things that happen in the military. It's very confusing when we're talking about the same person wearing the same uniform, the same office. It just depends on what status they're in.
Thank you for that. Committee, any other questions? Okay. General, you get the last shot at it.
I will cede that time, sir. I appreciate the committee's patience this evening and their desire to understand. Thank you, sir.
Well, and right back at you. We appreciate you walking us through so that we understand it the best we can, and we'll take it out to the Senate if it passes and do our best to help them understand the magnitude, and appreciate all the work. Thank you, gentlemen.
Thanks, sir.
Okay, we are done with public comment. I'm going to offer to the chairman of the House Transportation. Thanks for sticking around, you guys. Really appreciate it. I'm going to close public testimony. What's your pleasure on this bill? Senator. Okay, Senator McEwen moves the bill. Do I have a second? Second by Senator Pappas. Do we have proposed amendments? I'm not inclined to work it page by page, but gentlemen, if you have anything, let's go right to it.
I don't have to. Maybe if it passes. Might be some cleanup language. I think it's actually fairly well written.
Senator McEwen, that's a great suggestion. And I wonder, there's always the opportunity for us to get an update and visit during the next interim together. And, these are always, these statutes are always works in progress. And so, I think that's something that we could certainly come back on, or it's very possible that Mr. Smith and the general want to bring us something back, maybe something that we missed or forgot or whatever. So
I think,
Yeah.
Mr. Chairman, especially in terms, my military friends will understand. Mr. Chairman, I think in terms, my military friends will understand a bad plan executed well is better than a good, perfect plan executed poorly. So I think it's a good place to start. And it gets them some needed tools that probably, as we look through the history of some of the events with the Guard, that might have been able to be derailed before it exploded to some of the levels it has.
well put. Senator Pappas.
Yeah, and I think also, I'm heartened, I'm glad that Senator Ellis actually was attending tonight, and I could tell she was taking copious notes. So I really would like to confer with her. She may have some some amendments to the language that we might want to think about and run across the military department as well. You know, because frankly, any bill can always be made better. So, but I agree with a lot of the things in here, just from my background. A lot of the things that need to be changed, and there still may be a few things to tweak that we can improve upon. But I on and for the bill.
So thank you for that, Senator. And I maybe speak for Senator Furphy. I'm kind of glad these military guys are here, you know, just to help keep us straight out there on the floor. And I'm ready to go with this bill too. And I appreciate all the work that's gone into it through the interim with the Joint Transportation Committee and then on to this. So if we're ready, let's take a vote on this bill. What do you think? Kim, I don't believe that Senator thank you. So please incorporate that and let's take roll on this bill.
Roll call vote for House Bill 22 engrossed. Senator Anderson left an aye vote. Senator Furphy.
Aye.
Senator McEwen.
Aye.
Senator Pappas.
Aye.
Chairman Landon.
Aye.
5 ayes do pass.
Committee, I'm not sure how we want to handle that bill, but I was going to see Senator Furphy if you'd be willing to handle the education bill, House Bill 21. That first bill.
Oh, the
If you,
first bill.
yeah, the first one,
I would do that.
since you're an education kind of guy. We kind of loaded you up with these two. I could take the other one and you could take this one, Senator. What do you think? And I think that Senator McEwen is ready to help out too. Maybe we can split up. If you want to take Senate or House Bill 22, that would be great, Senator McEwen, and we will back you up. You got the cheat sheet. I think that'll be really helpful out on the floor, and we're right behind you if a fight breaks out, okay? No, that's terrific, Senator. Thank you for that. So Senator Pappas, you've got the middle one. Senator Furphy's got the first one, and Senator McEwen, you've got the third one, and we'll take them upstairs and go to work on them. Thank you, everybody, for tonight.